Right, people are still loading in, so just a few more seconds and then I think we can go ahead and get started. All right, go ahead, Scott. Mayor Fadness.
Thanks, Ashley, and thanks for everyone that can join us tonight. I know it's a beautiful night, and I appreciate people taking out of their time to come be a part of this important conversation. It's certainly something that's top of mind. I was remarking earlier before we got on the call that several news stations and newspapers and radio outlets interested in this, and frankly, and most importantly, I can't tell you how many residents I talked to recently, either anecdotally. They're trying to buy a home, but they're getting beat out by people with nothing but cash offers and no inspections, or whether just today I was talking to a police officer who was telling me that in his neighborhood, when he looks out his driveway and looks to the left and to the right, he sees these for rent signs and laments about, is this going to mean something to the homeowner or the home value of his particular home? I've got a really great panel of people to help talk about this tonight, and this really is dedicated to the neighborhoods and the residents who want to learn more about this issue and try to understand it. And so we're going to start very much at a high level about what is this, what are we talking about tonight? And then we're going to talk a little bit about what does it mean to fishers specifically. And then we've got a really great legal resource to kind of talk through these issues for you tonight at length. We've got a million questions that have already come in tonight, so we're going to try to tackle as many of those as we can. We're also going to be posting resources in the chat, some great white papers that we've been able to develop, as well as some legal resources. And if you have any questions tonight, Ashley Elrod, our communications director, she's going to be available via chat or on Facebook if you want to post a question or comment. And Megan Baumgartner, our economic development director, has graciously accepted the job of answering text messages. So feel free, and this will be in the chat as well. You can text us at 317-601-7779. Again, 317-601-7779. Let's start at a very high level. And if this isn't a headline that doesn't get your attention, I think it should. I read it just the other day that 33% of all homes purchased in the country in January in the US were purchased by institutional investors in January. That's an incredible number that just caught my attention. It was in Business Insider recently. And I've asked Jordan Alexander, proud HSE alumni. She's on our team and does a lot of policy work for us. And we're going to share a document that she's put together that really is a kind of really good brief of just what's happening in our country around this particular issue. But let's just start, Jordan, if we could, and you're on mute, so you may want to unmute there. When we talk about institutional investors at its basic level, what should a neighborhood understand that means?
Yeah, so institutional investors, it's really become kind of, the catch-all term for some of these larger groups. Typically they're owning more than 1,000 more homes across the country. So, it's not your typical mom and pop landlords with, one or two properties down the street that are, building their wealth by investing in property. These are most times, Wall Street backed funds, including banks. And even I saw cases of pension funds outbidding people to purchase some of these homes. So, generally these institutional investors, they really take in a much more corporate approach to the single family rental housing market. And that was something that, before then had really been traditionally reserved to the local level with these local landlords. So it's become much more bigger than that with these institutional investors.
And Jordan, one of the things I noticed in a lot of the articles you put together in this white paper that I found interesting is prior to this kind of phenomenon, a lot of these larger institutions that were buying homes were doing it in, post the recession or the housing bust of 2008, 2009, and they were buying what I would call distressed assets. These were homes that had tax liens on them, they were in disrepair, and they were buying large swaths of these. Talk a little bit about how today and what these articles are talking about is a departure from, let's say, post housing bust.
Yeah. Yeah, so sure. So after, yeah, the housing market crashed, obviously, there were thousands of vacant and foreclosed homes, and Wall Street kind of swept in to purchase a lot of these homes at a discounted rate. And, at the time, it was really looked at kind of as a stabilizing effect. And so it was looked at as a positive thing. A lot of these homes that, people had lost in the housing crash, they then had a place, they necessarily couldn't afford to have a house, but they could rent a house. So it was looked at as a good thing. But really over the last decade, the involvement of some of these larger investors has become more pervasive. And these groups have really sought to, I kept coming across the term professionalize the market. So, again, like I said, it had been once confined to the local level and local landlords. And so it really took on a much more corporate feel. And then obviously that has been just exacerbated by the pandemic where, you have a lot of these small time landlords that were exiting the rental business, really at record rates because they couldn't get rents on time. Government stimulus wasn't coming in on time. So at that point, investors saw another opportunity to continue to expand on investing in that single family housing market and really became, even more ingrained in the industry. So, throughout 2021, you kept seeing record after record being set of the percentage of homes being purchased by these investors. And then, like the mayor mentioned, just in January of this year, it was reported that 33% of homes that were sold were bought by investors. So yeah, that's a, pretty incredible number. And then once you factor in kind of the presence of these investors along with, this accumulating housing shortage that's been, kind of developing for years at this point, you've really kind of created, the perfect storm almost for some of these dramatic housing increases and housing cost increases, which all of that, obviously has proven, problematic for particularly first-time home buyers. You're competing with investors that can make cash offers. They have ready access to capital. So, you almost have zero chance with, as a first-time home buyer competing with these groups. So
I think, Jordan, one of the differences too that I noticed in the articles that you shared with me was their target is no longer a distressed asset. A lot of these purchases are in neighborhoods that, frankly, if you talk to a realtor, would have multiple offers from families or individuals that want to own and occupy that home.
Mm-hmm.
And now they're in the market competing against those individuals, which I think is a departure from what was happening in 2008, 2009, 2010. Is that fair?
Yeah, definitely. And I think the trend, it has been widespread for sure, but, there's definitely certain communities that these institutional investors kind of target. I came across a handful of articles where investors actually point out that, some of these more affluent suburban areas that have good schools, growing job creation, increasing household size. They really target those because that's where they can make, the most profit. And those are ultimately the communities that have the highest demand to live in with kind of lowest supply. But yeah, to your point, these aren't, blighted, vacant buildings that no one's living in. They're going up again against working middle class that are, first-time home buyers.
I think that speaks to also geography. So, the articles you found were from every corner of this country and including Canada. And maybe we're going to touch briefly on this and then we're going to move on to why it's important to fishers specifically, and then, some solutions at the local level. But talk about what you saw in the research around just federal, literally national governments trying to address this issue or tackle it all the way through to state and local. And really, it's kind of the Wild West at the moment from my summation that there isn't a real thoughtful policy around this issue. Can you talk a little bit about some of the things you've heard that people are trying or looking at from a national and state level?
Yeah, and I think a lot of the efforts are starting to gain traction now. I think, the pandemic did shed a lot of light on this issue. But yeah, to your point, I think now governments, like some at the local level and state level, are starting to put forth different proposals and actually having that conversation. But I think the biggest thing, what I found is these governments are kind of, struggling with identifying kind of the best path forward, because they're trying to balance of wanting to limit the large investors, but also not kind of impeding on some of these smaller mom and pop landlords that still exist. And it is hard to kind of differentiate between that. But overall, I mean, it has been a spectrum in terms of what I did find at the state and local level, and how these governments are trying to address or preparing to address these issues in their communities. So yeah, just like last week, Newark, New Jersey, their mayor just announced kind of a larger blanket proposal to decrease investors. So he's really targeting banning solicitation of homeowners. They mentioned in that community, you have homeowners getting knocks on their door 5 to 10 times a day from investors that are, making cash offers. So limiting that. And then on the other extreme, I know you mentioned even out of this country. So Canada, they just put a recent ban on foreign investment in the housing market. And that's just a temporary ban until everything gets kind of cooled down a little bit. But there's been municipalities here in the States that have kind of referenced that. Dallas, Texas, they have had conversations about what a ban on not just foreign investment out of the country, but out of state investment, if there's a way to regulate that somehow. So, but again, it has been kind of widespread from what I found, but I think now it just is starting to gain traction, and you'll probably start seeing a lot more kind of concise efforts and targeted. But I definitely think it's going to be kind of prescriptive to each region, because every area kind of has their own issues.
Well, Jordan, I want to commend you on your research, and Ashley, I know, is going to post in the chat as well as on Facebook your white paper on this, and there's a mountain of articles for people if they want to get up to speed on a national level of just kind of the churn and the conversation that's out there. But I do want to talk a little bit more about potential policy solutions here in a little bit, and I saw some questions about this, and we are going to get to those, but I want to bring this home to our community. Megan Vukasic, our planning director, is really, her efforts where she spearheaded our housing study was really kind of the first time that I went from an anecdotal conversation about this issue, where I would hear from time to time neighbors talk about it or residents talk about it, to where we really got our hands around what does it mean in our city? What does it mean in Fishers? And I think, we broadcast this tonight for not just Fishers, but for any community that's interested in this issue, because honestly, what's happening in Fishers is probably happening in the vast majority of other areas that are desirable places to want to live. And so I think there's some really transferable case studies that you can take from this. But Megan, when we looked at the housing study, the thing that jumped off the page to you and myself and others that were being briefed on it was this issue of investor-owned properties. Can you just talk about the magnitude of that in our community?
Yeah, so there's a couple of things that came out of that housing study that I think are really tied to this conversation. So one was just the number of investor-owned transactions that we saw over a 5-year period from 2016 to 2021. So in that time, that 5-year period, we saw about 10%, a little under 10% of all housing transactions were for non-owner occupants. So those would be people who are purchasing homes that are not intending to live in those homes. And so out of all of those transactions, about 1/3 of those were out-of-state investor purchases. So that showed us that, we're seeing an increase in the amount of investors purchasing our single-family homes. But with that, in our community specifically, we also have a high demand for family rentals specifically. So in the traditional sense of maybe multi-family rentals, you don't think of single family homes, but for Fishers, and Jordan had mentioned this a bit too, we have a strong school system and a great community. And so families do want to live here. And because of that, we do see high demand for family rentals. So the housing study showed there's a higher percentage of families renting. The rental market is extremely tight, similar to the housing market. And we see that with our 3-bedroom units are commanding higher rents per square footage than like a studio apartment, which is not typical. And then that 30% of all rental units in Fishers are single family homes. So that does show us that there is a strong family rental market here in Fishers. And
I think
because
it
of that,
also, sorry, Megan, I think the other part of that I found interesting in the data point was the median home value of the homes that they were purchasing was significantly higher than you would think for a rental home. I think it was in the $300,000 range was the median value of the home that they were buying to turn into an investment property.
correct. Yeah. And I mean, really, we've seen the price of homes increasing, right, year over year. And
Yeah.
so, yeah, it is high, the price per homes that these investors are purchasing.
And I think it's a perfectly rational economic argument for what is happening when you think about what they're contemplating. You have an asset, a home, that historically and projected going forward is going to appreciate in value because of just where it is, right? If our communities continue to do well, that home's going to appreciate in value. And in the interim, because we do have a strong or tight housing market, the ability to charge rent, significant rent, to get a return on your investment while that investment also appreciates is also there. So I don't fault the capital on Wall Street for identifying this as a lucrative option, but it does have consequences. It eliminates a lot of opportunities for families to accrue wealth. You know, a lot of families, I know I'm one of them, my family, the only wealth we've ever generated for the most part has been from making our life investment in our home, taking care of it, it appreciates, you sell it, and then it gets passed down through generations. And so if we take away those opportunities for homeowners, that has a downstream effect that I think is negative. But also, Megan, we did some homework because I never want to be one to just operate in anecdotal stories or kind of stereotypes. So we took a look at code enforcement issues on homes in our community. So if you take the average owner occupied home versus the rental home and you look at code enforcement, can you talk a little bit about what we found regarding the statistics around that?
Yeah, so we looked at rates for last year just because that's the most recent data we had. And we found that community-wide for single family homes, we have about 4 code enforcement cases per 100 homes. So that's for all single family. When we ran that same information for out-of-state investor-owned single family homes, those are only out-of-state investors, we found that it was about double the amount of cases. So it was about 7.8 cases per 100 homes. So that is a really significant increase between those two. That is something that we as a city need to be aware of, but shows a need, or I guess an issue, an additional issue with these out-of-state investor purchases.
Well, I certainly think it affirms a concern on the behalf of the homeowners that reside in these neighborhoods where they're seeing significant turnover. If we show statistically that they are twice as likely to have code enforcement issues, those are things that HOAs and neighborhoods are going to be concerned about and challenged with. And so I really appreciate, Megan, your work on the housing study to bring this to our attention. And I think even our consultants were surprised when they looked at the data to demonstrate that, man, this is a significant trend in our community. And I would venture guess if you're a Carmel resident, a Lawrence resident, a Westfield, Noblesville, Greenwood, you're likely, your numbers are probably not that different than the city of Fishers. So with all this, I want to take the majority of the time tonight to provide this resource. Kim Sutter with Eads, Murray, and Pugh is here tonight, and she is, for lack of a better term, a foremost expert on this very issue. And before she gets started, I want to explain why we're focused so much on the HOA level. And honestly, it goes back to Jordan's summary earlier, is that I think cities, states, the country are just kind of waking up to this issue. And there isn't really a lot of strong policy and law put in place at a broad level, at a citywide level or state level, to try to address this issue. Now, I know Senator Kyle Walker, our senator in Fishers, we had a conversation this morning, He's very interested in this issue. Speaker Houston wasn't able to be on here tonight, but I know he has his staff watching. So it is something that I think is piquing the interest of legislators. But until we can formulate some of that, and we'll talk a little bit about that later, the best thing that we can do is provide resources to our neighborhood level, our HOAs. And so, Kim, thank you for taking time tonight to be a part of this conversation. As we were talking about before we got on here, there really isn't a day that goes by where you're not getting called these days to talk about this very issue. So if you're someone new to this, and let's just start at a very basic level, what is it that an HOA, a homeowners association, has that would allow them from a legal perspective to even talk about or try to address this issue?
Yeah, thanks for having me. First of all, I'm very glad to be here and to talk about this issue. From a community association standpoint, every homeowners association, condominium association, townhome association has a set of governing documents. There's a set of covenants and restrictions that are on the property that are part of the chain of title for every property in that subdivision that has use restrictions and, standards for maintaining your property and, all kinds of information on what you can and cannot do with that property when you buy property in that community. So that document, the covenants and restrictions, is where we legally, when you call us, that's the first place we look to see if you have any sort of restrictions on rentals, if rentals are allowed in your community, if they're not, and how you go about changing those documents if necessary to deal with some of these issues with rentals. Like you mentioned, we do get contacted about this issue extremely regularly. And there's different options that communities have at their disposal to talk to their homeowners and get an idea of what types of restrictions the community would like to see in place, and then take steps to try to amend those governing documents in order to put these in place for these communities.
And Kim, I know tonight, you're going to be making a lot of broad general comments because you don't have the luxury of looking at everyone's individual situation in the context for that.
Right.
But should people assume that if they're in an HOA and they have covenants, that most of them have language regarding rental restrictions? Or in your professional opinion, is that a standard language, or is that something that really it's hit or miss?
It's pretty hit or miss. Most of the documents are all drafted by the developers of these communities, and they're very developer centered. So they take care of what needs to be taken care of during the development process. Occasionally we will see language that specifically says rentals are permitted, or we will see that language that says if you're going to have a rental, you have to provide a copy of the lease. Things like that, of that nature. It's very rare that we see any developer drafted documents that have very specific restrictions on rentals. And I think part of that is because they want, from a sales standpoint, to be able to sell the units.
That's a really great insight, so that people should not assume that
Right.
the people that drafted these were thinking about the long-term viability of the neighborhood. No offense to the developers, but they were really focused on, trying to get the development up, going, sold, move on. So in reality, they should assume that there's not language in there and really go look to figure out what's going on.
Correct. I mean, I do get a lot of questions where people will see language in their governing documents that says, well, it says that our properties have to be used for a residential purpose. Well, this is a rental, so isn't that a commercial use? And there's actually a lot of case law nationwide that says that that's not the case. Like a rental or a lease in your community is still being used for a residential purpose. So that's not a commercial use of the property legally.
Yeah, Kim, I'm glad you brought that in. I want to bring this up with Megan Vukovic as well, because we probably would get the same question. Megan, from an entitlement or from a zoning perspective, the difference between someone living in that home as a rental or living in it as a owner occupied, from a use perspective, the law doesn't see that as a different use. Is that fair, Megan?
Correct. Yeah, we would only regulate the residential use, not necessarily if it's owner occupied or rental.
And I think, Kim, that's something that, before we get into the tactics of what you would do or how you would look at this, a lot of people start to talk about discriminatory acts. And from a legal perspective, can you just talk about why that's a concern when you start having these conversations, and how is the concept of discrimination brought into a conversation about whether or not I want 5 rental homes in my neighborhood or 20?
Yeah, I think it becomes a topic of conversation because certain protected classes are seen as being more likely to rent a property than they are to buy a property. So, and you know, some of that has shifted over time, but as when you start talking about discrimination and covenant restrictions, sometimes something may not be discriminatory on its face, like it looks like you're not picking on or, you know, discriminating on the basis of a protected class under fair housing laws, but that restriction may have a discriminatory effect when it's applied. And so there have been some challenges in the past on rental restrictions that went to the Indiana Supreme Court, and the Indiana Supreme Court actually upheld the rental restrictions as not being discriminatory. And part of it is because these community association covenants are private contracts that each homeowner agrees to when they buy the property. So the person who is, you know, renting that property out or restricting the rental of that property, the intent of that has been agreed to when they purchase the property. So the Indiana Supreme Court at this point is supportive of rental restrictions in community associations.
So let's assume we're an HOA president. You're hearing from your residents that this is an issue. You go to your attorney and you say, "Hey, we want to restrict these." And let's assume also, based on what you've said, Kim, that the likelihood that you have strong language in there is probably not great unless you've already adjusted this post development turnover. What are the options when it comes to restriction? What are the typical standard? You know, is it a percentage of homes? Is it a cooling off period? You know, what have you seen as tools that neighborhoods can use?
Yeah, there's a couple of different options out there. We have some communities that want to go for a total rental ban. Of course, those are a little bit more difficult to get past because you have to have, you know, a lot of buy-in from the community. There's, like you mentioned, there's an option for a percentage rental cap where only a certain percentage of homes within the community can be rented at any given time, which can be a little bit of a administrative nightmare, if you will, at some point, because you have to establish the number of rentals in your community and keep really good records and have waiting lists. And so that can be very helpful for a community because you can allow some rentals in your community, but keep them at a low level or at a smaller number. Another option is the cooling off or waiting period that you just mentioned. I've seen communities do anywhere as short as 1 year up to 5 years of the property having to be owned by the owner occupant before it can be eligible for a rental or a lease. So that helps detract some of these investor owners because they don't want to have to sit on the asset for that long before they can reap any benefit.
And so let's say, go ahead.
There's also a hybrid approach. We've had some communities that want to do the rental cap along with that waiting period. So it's kind of a little bit of a crossover, so that even if, because the drawback of the waiting period is that you may eventually, if you have some longevity in your community, you could reach a point where everybody's on their home long enough and then you still have a lot of rentals in your community. So some communities will double those up so that they can still keep the numbers low.
So let's assume you're the HOA president, you've met with your attorney, and you and 2 of your board members have come up with a plan to implement some language. There's a great question that just popped up. You know, typically for an HOA, if they're going to meet with you or a law firm, what kind of cost is associated with amending the covenants typically?
Oh, I'm gonna give the lawyer answer and say it depends, but
Yeah.
it's really gonna depend on how their documents are crafted and worded, what the thresholds are for getting the amendment passed. So one of the things that we would do initially is look at the covenants and see, okay, what do we already have to work with? How much do we have to change? And what are the thresholds to get these documents changed? So how much legwork is there gonna have to be? We would talk to the community and say, how many meetings do we have to go to? Or how many meetings are you going to want us to be at? And some, we have some higher involvement in some associations, some lower involvement in others. I mean, but from a budgeting standpoint, I mean, the association has to be prepared to spend probably anywhere between $800 to $1,500 to get these things drafted and put together.
And then, Kim, I think one of the things I've heard a lot from HOA presidents that have tried to do this is the heavy lift to get it approved. Even
Yeah.
though in general, maybe a lot of the residents agree with the concept if you went door to door, but these thresholds to amend covenants, the percentage of voting seems fairly high for approval typically.
Yeah, it can be. Some associations, some of the luckier ones have some lower thresholds where they need maybe a majority or 2/3. We've seen others that go as high as 75%. And then there are some communities even still that their documents say they're required to have 90% of the homeowners vote on these changes, but the legislature actually stepped in and made a change to the Indiana HOA Law Act that says that the most that you could require to amend the covenants is 75%. So some of the communities that have those higher thresholds don't realize that really they don't have to get 90% in order to get there. So
I'm
that's
gonna jump in here. Kim, we've had a few questions around this. For those that do already have that threshold for the 3/4 votes, but perhaps their neighborhood is 30% investment rentals. How does an HOA manage around that situation?
So there's a way to craft the language where you can grandfather in existing owners so that anyone who's currently owns a unit that is renting it, that at the time you would record the amendment, they could continue to rent the unit for the entire rest of the time that they own that property. But as soon as they sell it or the property changes title in any fashion, that right to rent drops off, that grandfathering drops off, and any new owner is then subject to whatever the restrictions that were adopted are at that point. And sometimes that can help ease that vote because they still get to maintain the use of the property that they bought it for, but that the next owner then is limited.
Right.
Well, Kim, one of the challenges too is just so let's say by some miracle you get 85% of the people to vote for it. What happens if the percentage of the homes that are already there are above the threshold? Are they automatically grandfathered in typically? I doubt you can. That's a taking almost if you were to try to.
Right.
So those folks that are already renting, these institutional investors that are already there, there's really not a way to change that out, I would assume.
That's correct. Those folks would need to be grandfathered in, and all the other issues that come along with this, where we've talked about potential for not maintaining the property the way a home owner occupied homeowner would. Then the community associations have their covenants enforcement at their disposal to try to force that and to make sure that those properties are properly maintained.
And Kim, one tactical question I have for you. So you're an HOA president who's doing this voluntarily. It's the most thankless job in the world is being an HOA president. And let's say you get this passed and now all of a sudden you're supposed to keep track of there's no more than 5% of the homes in the neighborhood are for rent. How do they go about managing that or tracking that? And then what are the enforcement tools if they find someone not in compliance?
Yeah, so the tracking is of course the administrative piece that can be a little bit difficult. Part of the amendment process and part of the language that we put in the amendment is that anyone who is renting the property within that community has a duty to provide a lease to the homeowners association. So they can take out any of the identifiers. We don't need to know how much they're charging. We don't need to know, social security numbers or anything like that for the tenants, but we need to know what the term of that lease is and the terms of that lease so that we can make sure that it shows that the tenant's supposed to be maintaining the property or that they're not, and it's supposed to be the rental company that's going to have a company come in and do the work. So if they don't provide those documents, then now we are in a position where the association has an enforcement piece. So Indiana law states that whenever there's an enforcement issue with a community association, the association has to send a formal notice, and we have to go through a grievance process and offer a meeting to try to mediate the issue before we would actually get to the point of filing suit. So some of the issues, if it has to do with maintenance of the property, or you have tenants that are not otherwise adhering to the rules and regulations of the association, for like behavioral issues and things of that nature, the association has the ability to get injunctive relief through the courts to force some of those issues and to force the maintenance of that property. And if these companies don't abide by the court orders, then fines can be imposed by the court, and the association can have the right then, if the documents are crafted properly through the injunction, to go on the property and make the changes and charge that owner for all that work.
Well, great. I want to remind everyone, if you want to shoot us a text with a question, 317-601-7779. Again, 317-601-7779. I am going to step back, and Kim, you're doing a great job. And I know we have a lot of people that are very interested in asking you questions. So at this point, I'm going to turn it over to Ashley Elrod and Megan Baumgartner, if there are questions that they have from the audience, so to speak, to go ahead and fire away.
Absolutely. So just generally, are these restrictions that you're mentioning, how are they holding up in court? And there have been several comments about traditionally covenants not being supported in court. I know you've mentioned some case law that has supported that. So can you speak to that?
Yeah, we've had success with getting, with enforcing rental restrictions in the courts locally. So, other than that case I mentioned earlier, nothing's gotten quite to the level of the Supreme Court, but most courts will recognize that the governing documents are a contract, and that, as individuals who buy property in that community, that they've agreed to the terms of those contracts. And so if they violate those, then the association does have that right and that tool to go and try to enforce that through the courts. And our firm specifically, and I know other community association firms, have been successful in enforcing these rental restrictions in the courts recently. Was there another part to that question that I missed?
No, I think okay. You answered it. What are some successful tools or processes you've seen HOAs use to get those amendments passed? A lot of individuals here are concerned just about even getting 75% participation, or even if those rental property firms, if they are grandfathered in, many don't send in proxies for votes, things like that. Any tips for those HOA leaders? Yeah,
there's a couple of different ways that you can go about getting these passed, other than just the traditional going and knocking on doors and putting boots to the ground kind of a thing. There's the typical voting in person or by proxy at a meeting of the association. The Nonprofit Corporations Act also allows voting by mail-in or written ballot, so that ballots can be sent back by email, fax, any sort of electronic means, that you don't have to have a formal meeting if you go through the process that's set out in the Nonprofit Act. So that's an option that a lot of community associations have taken advantage of. We had a recent association who put out one of these rental restrictions to their community, and managed to get the responses back. Within 10 days, they had all of these written ballots back, because it was an extremely, they had a lot of buy-in from their community and they really wanted to get it done. So it happened a lot sooner than anyone anticipated. That's probably the best success story I've seen. And then there's also the ability to, if your documents allow for electronic voting, which some community association documents are starting to finally catch up with technology. And the advent of platforms like this with Zoom have also helped with that and kind of push the technology issue. And so electronic voting is being used a lot more often, and communities are looking at changing their bylaws, especially if your bylaws can be changed by board vote, to implement those kinds of procedures so that it makes it easier for people to vote and they don't have to come out to a meeting. And so we've seen more success with recently because of those technology tools.
That's great. Is there any sort of timeline or restriction on timeline to get those approvals once it's proposed?
It depends on the process that you're going to use to get the approval. So if you're going to do it by a traditional meeting method, you can stretch the process out a little bit by holding that meeting open and going out and trying to get the votes until you get enough. If you use the mail-in ballot process or the written ballot process through the Nonprofit Act, you have to provide a drop date by when the homeowners would have to return the ballot so that you have an end date where you would cut it off at that point and then count and see where you are. So there's drawbacks and benefits to different methods because some you can stretch out, other ones have specific timeframes. And then the electronic voting too, depending, that kind of takes the place of a meeting. So those can kind of be stretched out a little as well. You got to be careful about stretching it out too far though, because if you have properties that start changing hands, then you have to go back and have those homeowners revote if somebody's sold in the interim. So it's a little bit of a, record keeping thing that you have to kind of keep track of depending on which process you use. And, usually we will talk to the association when they come in and want to do these types of amendments to figure out what's going to work best for that community.
Are there any options to add deposits or yearly rental fees in addition to yearly dues for investment companies who are buying in your neighborhood?
You have to be really careful about treating different classes of owners as different and subjecting them to additional fees and things of that nature, because at that point, that's where you start getting into the association being, targeted for suit because you're treating a specific type of owner differently than everyone else. The way that community associations are set up is that every owner, regardless if it's an LLC or an individual homeowner or, a partnership or trust or however the property is held, they're all treated as a member in the same fashion. And you have to treat them all the same in the application of all of your rules and regulations. So the second you start doing that is when, and trying to treat people differently and charge them additional fees to do things is where you start buying issues as a community association and subjecting yourself to lawsuit.
Yeah. When the court sides with the HOA, how often is the HOA able to recoup their legal fees from your experience?
So that's going to entirely depend on how your enforcement provisions are written in your governing documents. If your enforcement provisions say that the association can recover their attorney fees for any enforcement action, then we typically will get awards for attorney fees. But, the general rule is that everyone pays their own attorney fees unless there's a contract that says otherwise. And because the governing documents are a contract, if that language is in there, then we can recover our attorney fees. If it's not, and I do see community association documents that do not have that language, then we can't recover the attorney fees in that type of a scenario.
Yeah, absolutely. We're getting a lot of questions around enforcement and enforcement of covenants and so I don't know if we want to skip over to that outside of covenant HOA.
Yeah,
I'm sorry. Ashley, you're gonna be more specific. Are you talking
I'm
about
sorry,
state
just
code
around,
enforcement?
we're receiving a lot of questions just around maintenance and repair of these homes, and how much authority the HOAs have to enforce those.
Mhm.
I think, so this is always a conversation that we get into when we talk to HOAs. Kim, you can touch on the HOA language, and I'm sure it varies depending upon your HOA.
Yeah.
Megan Vukovic, you could probably talk from our perspective. You know, one of the things that we're restrained by currently is, you know, unless it's a life safety issue or, you know, weeds and grass, the fact that you don't like the lack of paint on the trim on a window, that's a very difficult thing under Indiana law for the city to go in and enforce. So Kim, maybe you can talk about it from an HOA perspective, and then Megan, maybe we can talk a little bit about what we have on the books from a code enforcement standpoint.
Yeah. So from the HOA perspective, part of the purpose of a community association is to maintain property standards within the community to enhance and maintain property values. Like that's part of the whole point about why community associations were ever founded. So part of the role of the community association is to maintain those community standards. And if you have a property that's not doing that, then you do have the enforcement abilities to go after those homes to try to force that maintenance. Now, some community associations have language in their documents regarding the association being able to do some of those maintenance items after a proper process and then charge the homeowner for those costs. Now, the downside to that is the association has to front all of those costs and hope you can recover it from the homeowner. So, and that may end up with the property ending up in foreclosure if the homeowner is unable to pay. So there's all sorts of, different ways that the association can go about some of these things, but we have to look at the governing documents to see what options are available and go from there. One of the things that Indiana as a state is kind of lacking in is I started my practice in community association law in the state of Ohio. So I'm licensed in both states. And in Ohio and in many other jurisdictions around the country, community associations have the ability to put out enforcement assessments if someone is not maintaining their property or has otherwise violated the covenants. And we have case law in Indiana that says that we can't do that here. And I know that, I think that would need to be changed at a legislative level in order to get that changed. And we're hoping that eventually we can get there and we can help model some legislation after some other states that have been very successful in putting those types of remedies available to community associations, because it keeps these types of maintenance issues out of the courts, which most judges would appreciate, I am sure. So that's something, kind of looking forward at as an industry that we're trying to do. But for right now, I mean, you have to use what's in your governing documents, which is the traditional injunctive relief, or if you have self-help provisions in your governing documents, to go that direction to force some of this maintenance.
And I think, Kim, the same kind of my experience in Indiana legislature is that it's a strong property rights state.
Yes.
My home is my castle. I don't
Yes.
want government involved. And so the idea of a community association and really even cities interfering in a person's property without a compelling life safety issue or public health issue has been fairly
Difficult.
limited.
Yeah.
Not to say that that can't be tried. We can't try to change that, but I think it's just important to understand kind of the reality of where we're grounded. And Megan Vukovic, maybe you can just talk about from a code enforcement standpoint, what is the area or the breadth of enforcement that we have currently under Indiana law and what we have on the city of Fisher's books?
Yeah, so I would say there's a couple of property maintenance things that we can enforce. So we have our zoning ordinance, and so we do regulate inoperable vehicles or outdoor storage, trash and debris. That's regulated through the zoning code. And then from a property maintenance standpoint, as Mayor Fadness mentioned, it's really hard to regulate property maintenance if it's minor issues. It has to be life safety. So unsafe buildings would be enforceable. And then high weeds and grass is also considered a public health and safety issue. And so those are really our capacity to enforce as a city. Those would be those things. If you are concerned about code enforcement issues on a neighboring property, you can submit those complaints through the City of Fisher's website. So if you go to the public website, one of the tabs at the top is how do I, and then it gives you a drop-down list and it'll say file a code enforcement complaint. If you click on that, you can file the complaint and one of our city inspectors will go out and assess the property and cite any violations that are present.
Other questions, Ashley?
Yes. What role can the city play in overarching limiting the number of properties that are owned by one entity across the community and then within neighborhoods outside of the HOA?
Yeah, I've seen a number of people throwing that up in the chat, you know, do this, go do this, city, why haven't you done this? And I think it's important to note, and Kim, you can jump in here because you've practiced in other states and looked at this. And Jordan, I think it speaks to the articles in the conversation that we've had to date that frankly, this has just not been an area that most municipalities have put a great deal of laws on the books. And we're open to the conversation, but as complicated as it is at an HOA level, it becomes even more complicated when you go to craft a law around this particular issue at a municipal level or even a state level. And so, you know, Kim, I don't know if you've had experience with municipalities from a broad brush law perspective in Ohio, but certainly in Jordan's review, and I don't want to speak for Jordan, but we didn't find, oh, well, there's, you know, 1,000 cities that have already tackled this, and here's the playbook for how to address this issue.
Yeah, no, I haven't seen a whole lot of municipalities try to tackle this yet. And I'm actually part of a national organization that for community associations. And I've put this out to the entire group of the College of Community Association lawyers and said, has anybody successfully done any of this? And I'm waiting for responses on that because I think this is such a big issue. I know that there are some municipalities in other states that have tried to get these investment companies to at least register to rent, but I mean, finding out if they are actually renting and then how to enforce that is a whole nother issue. So, I mean, putting some roadblocks in place, I think is being tried on the municipal level in other areas for things like short-term rentals, which we've seen and has been in the news locally as well, like with Carmel trying to do the short-term rental bans and things like that. And I think where, you know, it's hard on a state and municipal level to enact some of this is because of the constitutional arguments with the rights to own property. And so it's a really delicate balance on what we can and can't do and try to put forth from a legal perspective that would stand up to constitutional scrutiny.
Yeah, and I don't know, Jordan, if you found any, I mean, you saw a continuum, frankly, of, you think you mentioned New Jersey, it's trying to get creative and at least try to cut down on solicitation, but that tells you that people are nibbling around the edges, trying to figure out how you try to address this. I don't know if there were any great examples of municipalities or states that have tackled this.
Not necessarily. Again, the rental restriction components were really focused at the HOA level from what I could find. And the HOAs have really been leading in that regard. Again, as Kim kind of mentioned, what I found at the municipal and state level is it is kind of finding that delicate balance of, you know, balancing this discriminatory component along with, you know, not wanting to block some of these lower level landlord investors from the community. And a lot of times I found it's really hard to track some of these LLCs. So even differentiating between, you know, these larger investors versus, you know, your mom and pop investor down the street is really difficult. So again, I just don't think there's a clear path forward of how to address that effectively yet.
So Kim, I want to turn it back over to you. Well, Ashley, is there another question?
Well, I was just going to ask, a few questions have been in regards to out-of-state companies owning these real estate, these these rental homes. And, they're asking about if there are laws that can prevent that from occurring. And I'm assuming there's some pretty simple ways for these folks to get around that, but just if you could comment on what you've seen across the country.
Well, I think Jordan mentioned this earlier, Canada tried to put a ban on foreign investment. It is exceptionally complicated and I think Kim spoke to this constitutionality, equal protection of the law. What does that look like? And so as a city leader, I'm very interested in this issue and I want to solve it. It is exceptionally complex, and trying to identify the right solution moving forward is going to be difficult, to say the least. And that's really tonight why we asked Kim to be on here, is because we do know there is a tool at the local level, at the HOA level, where you can make some discernible progress towards addressing this issue in your neighborhood for your sake. I think at the city level, we've engaged law firms. We've started, we literally sit in our office brainstorming on trying to figure out what is the policy that makes sense for this. And then you got to try to sell that at a state legislature, or try to figure out how you have the enabling legislation from the state legislature to even pass such a thing at a local level. So whether we're talking about how you discern between an out-of-state investor or a local investor, or whether you're trying to figure out how a city can just move in and take care of this issue, you still run up against a lot of the same challenges.
Referring to the origination of these covenants coming from the developers, are there policies in place for the PUDs that are going before the committees today that can prevent this from happening, or consulting to those developers to incorporate this language as it's being approved?
I think it's an interesting question from a legal perspective. And Kim alluded earlier to the fact that the reason they're able to do it from an HOA relationship with a resident is that it's a voluntary act to enter into that business agreement. I think the question that we would have to ask, and we just have to think through, is if I mandated at a city level to put that language in, does that constitute some sort of discriminatory act? And that's just things that we have to think through and work through and try to address as we move forward. Ashley, do you have another question?
Is there anything that the consumer can do, whether it is the home seller or your average consumer just trying to purchase a home? Are there any things that they can do to protect themselves, or to be able to compete with these investment groups?
That's an interesting question. I think as a home seller, you have the ability to sell your property to whomever you choose. So from the seller's perspective, it's difficult to tell a seller, don't take that buyer who's going to pay you over asking price for your home and make that profit to benefit a neighborhood that you're leaving. I mean, that's a pretty jaded, kind of a view, but from a selling perspective, that would be incumbent on that seller to not sell to the investment company, to choose not to do that. Or if you're in one of these communities that already has rental restrictions and you're looking at selling to one of these companies, it's the seller's duty to provide those governing documents to the purchaser as part of the transaction and the sale of that property. And so if you're not doing that, then then your buyer is immediately going to hit a roadblock, because I can guarantee you they're going to get an immediate letter from probably my office or any other community association attorney, any of the other firms that do this in the area, that says, hey, we see you just bought this property. Here's the rental restrictions. You can't rent the property. We're at our cap, or there's a waiting period, or there's a ban. So sorry, you just invested in this property, but you can't use it the way that you intended to when you bought it. So from the seller perspective, I mean, as a buyer, you're going to have to, make your offer attractive to that seller. However you do that, even if you can't match it in price, I mean, you can always appeal to the seller if you can, as a, family or, an individual who's going to live in the property, and see if you can convince them. But that's between the buyer and seller. I mean, we can't step into that and regulate the sale, or the intricacies of how those properties are sold.
Where would a neighborhood start if they don't currently have an HOA? How could they go about forming that and to protect themselves from these?
Ooh, forming an HOA after the fact is a little bit more difficult than it sounds. I mean, it's doable, but you would have to, each homeowner within that community would have to officially opt in and sign the agreements and the governing documents and opt in. And you may have, a couple of homeowners within that subdivision that's not an HOA that refuse. And then those are the ones that are not going to belong to that community association. So forming them after the fact is doable, but it's difficult to get buy-in from everyone.
Oh, another question is, if you're making changes to your documents for this rental situation, do you recommend just making that single change, or since you're changing it for this, that you go ahead and incorporate other changes as well?
I think if you're going to go through the process and there's other things that you need to change, you might as well do them at the same time. Some associations will do what we have sort of coined in our office as the 2 bites at the apple approach, where maybe you have a really high number of folks, you're at that 75% threshold, and you want to reduce the number of people that you need to amend your governing documents, that they'll propose changes to that provision and propose the rental restriction because people want those. And then so that the next time you go to amend your covenants, you have a lesser threshold to hit in order to get there. And then they'll go back and change the entire and revamp the entire document and, update it for today's standards and take out the things that don't work for your community that maybe the developer put in 20 years ago or whenever your community was developed that just don't make sense for your community anymore, and make those types of changes at that point. But yeah, I mean, this isn't just rental restrictions. You can change any of the items in the governing documents in accordance with how your amendment provisions are set up in your governing documents. So if they say that you can amend any provision by 75%, then great. There are some that will have different voting thresholds for different provisions depending on what they are. Well, they'll have like a 2/3 for everything, but then they'll have a material amendment provision for things like changing how you do assessments or changing how you insure the properties, or, they'll have a laundry list of things that require a higher percentage vote. So you just have to be careful about what it is that you're amending and how you're going about doing it, that it complies with the requirements in your governing documents.
Great. You had mentioned before short-term rentals, things like Airbnb or VRBO. How do these rental restrictions apply to those scenarios, or even temporary relocation? If they're perhaps out of the country for several months at a time, how does that play into some of the scenarios that you've experienced?
Yeah, typically when we do these rental restriction amendments, there's more to it than just the cap and the waiting period or the ban. There's the requirement to provide a lease. There's the requirement that you can't sublease a lease. There's a potential for a requirement that no less than the entire unit can be rented at any given time. So you don't have boarders in homes and things like that where they're renting out a single room, or that leases can't be for less than a year or less than 6 months, or there's a minimum requirement that would then prohibit those short-term rentals from being in the community. And then there's also the ability to write in what we call a hardship provision. So let's say you have a complete rental ban, but you have somebody who is temporarily relocated for a job, or is active military and is going to be out of the country for the next 2 years, or, you know, there's any laundry list of things that you can write in as a potential hardship that the board can then take those individual situations into account and grant an exception for the relocation or for the active military person, or to make those situations a little bit more palatable and easy. I had a situation where there was a complete rental ban in a community, and they had a homeowner that was going to be on a mission trip for 2 years. And they applied to their board of directors for a hardship exception under the restrictions in their covenants. And that was granted because that homeowner was going to come back eventually. And they had said, here's my tenant, here's the lease, this is what the situation is going to be, here's how you contact me. I'm going to still be paying all of the assessments, so that, you know, everything was in place. And so the board felt comfortable with granting that limited exception in that circumstance.
I know, Ashley, we could probably be at this all evening. It's a very salient issue. And Kim, you've been very gracious with your time tonight. And but I always want to be respectful of keeping these Twilight town halls to about an hour. Kim, is there any last kind of bit of advice you'd want to give these HOA presidents that are, you know, voluntarily doing this, that care about their neighborhood? You know, what's the takeaway from tonight that you would want them to have around this topic?
Yeah, I think one of the biggest takeaways is, you know, a lot of times, you know, being on a community association board as a volunteer is a very thankless job. And I think, you know, sometimes the members of the communities just want an opportunity to be heard and to talk to the board about issues like this. So having an informal town hall meeting with your owners to talk about, okay, what about rental restrictions? Are we interested in something like that? What would we want them to look like for our community? And having those conversations early on and involving the homeowners in the process, whether it's a rental restriction or any other amendment for that matter, getting buy-in early and talking about the process and what it is you're trying to do can go a long way in eventually getting the votes you need. So really sit down and figure out as a community what it is you're looking for, and make sure you call legal counsel and talk to us about what it is you're looking for. We can talk you through the process. We can talk to you about options that are available to you based on how your documents are already worded. We can give you suggestions for language and changes that we think could be helpful. And we can talk through some of those things and, you know, help you get through the amendment process.
Well, thank you, Kim, and Jordan, Megan, Ashley. Thank you for your time. I saw a lot of comments tonight about, Scott, why don't you just go fix this at the city level? And I want to make sure people understand the reason we're talking about the HOA piece of it tonight is because it's the quickest path to meaningful action. That's not trying to pass the buck. That's just the reality of where we find ourselves right now. I do fundamentally believe this is an issue. Philosophically, I think it's robbing a lot of people of the opportunity to accrue wealth for their families, which I think is not good. And secondly, I don't think it's good for neighborhoods and the people that have invested their life savings in their neighborhoods. It's a big investment for everyone in their home. And so I'm committed to trying to identify a solution at a broader policy level, whether that's at a city level or a state level. Chris Greisel, our city attorney, and I are in lots of conversations about how we go about doing that legally. But as we've talked about here tonight, Jordan touched on this, Kim touched on it. No one in the country has figured out how to do this yet. Now, that's never stopped us from trying to climb that mountain, and we will. But in the interim, we're trying to give you as many tools as we possibly can for you to try to address this at your neighborhood level, because we think it's important for you and we think it's important for our community. Don't forget that we have posted a number of resources. Kim's got a fantastic PowerPoint that kind of summarizes a lot of the things we talked about tonight. We're going to post that on this site, as well as probably on our website. I assume, Ashley, these resources will be available, or a Facebook post, as well as Jordan's summary of kind of nationally what's occurring, and Megan's housing study as well. So there's a wealth of resources there. And as we go forward, if there's more questions, more conversation about this, we can always jump on another one of these and hopefully answer additional questions. But again, thank you to all the HOA presidents. I feel like my life's an HOA meeting, and I know how difficult it can be. So thank you for doing it voluntarily. And let's stay in touch and let's try to tackle this issue. So everyone have a wonderful Thursday evening. Nickel Plate Trail's opening tomorrow night. It's going to be amazing. If you haven't seen the tunnel, it's awesome. And Saturday is the big opening. So come on out, enjoy the farmers market, and have a great weekend. Thanks, everybody.
Thank you for having me.